Yeah, that's okay.
All right. I did. I did. All right. Let's share my screen and we can start. Whoops. Like that. All right, we're going to start. Sorry, guys. All right. So Maryland Realtors sent, you go onto the email, I think it's from the email I sent out to you guys, or you can go on the Maryland Realtors website. This is just kind of a summary of everything. And Paul, I don't think you have this, but the tenant's right of first offer and refusal. It establishes 3 scenarios where a tenant is granted either an exclusive negotiation period or a right of first refusal to purchase their rental property from the landlord. This law went into effect October 1st. So now any properties that have tenants, or if it's a landlord situation, they're going to have to give notice to the tenant for the option to purchase the property 30 days. They get a 30-day notice to purchase, either purchase or not purchase it. So I'll go through this whole thing. The exclusive negotiation period, pre-listing. The landlord will provide to the tenant a notice of solicitation of an offer of sale along with the material terms of the offer the landlord will consider. So the landlord's going to tell the tenant what they would consider selling the house for. The landlord will then have to send a copy of the notice to the landlord, the Office of the Landlord and Tenant Affairs. And I'm going to take you to that right now. It's a website that they're going to have to sign in, and tenant's first right of refusal. The landlord's going to have to, they're going to have to sign in, set up their property, and do this all through the landlord tenant affairs. This is a big deal of what's happening here. The tenant has 30 days to respond to the notice with an offer to purchase. If the offer contains the same or more favorable terms than what the landlord provided in the notice, the landlord will accept the offer. So the landlord says, I'm going to sell it for $500,000. The tenant offers $500,000. The landlord has to take that offer.
So they are required to take that acceptable offer.
It says terms. So like, I guess if somebody would, that's questionable. And in practice, I don't know that if somebody comes in cash $500,000, if that's considered a more favorable term. In my mind, it is. But anyway.
Do they have to qualify?
They have, not at that point. I think they have to be, so they're pre-qualified. This is all the wild west right now, a little bit. So, so if the other offer does not meet the material terms, the landlord will deliver a counter offer. So if the tenant offers a different offer, the seller can counter offer that offer. The tenant has 5 days to accept the counter offer. If the tenant does not respond to the solicitation of the offer within 30 days or to a counter offer within 5 days, the tenant's rights are extinguished. So they have 30 days from the offer that the landlord gives them. If they come back and they say, we'll offer less, the seller says, no, I want this much. They have 5 more days to decide if they're going to take this or not. And then the landlord, no, I'm sorry.
Julie, so I'm just, because I see that there's 5 days for them to accept or reject the counter offer, but it doesn't appear that there's a time frame for the landlord to respond with that counter, correct?
Yeah. So when we get into the addendums, I think it's going to be more clear of the time frames.
Okay.
because I think that there is actually I think it's I think it goes back and forth 5 days, if I'm not mistaken, but we'll go through that. This is new to me too, so I've read it several times, but it's still, like I said, there's still gonna be a lot of questions. The scenario number 2, the offer after tenant negotiations. After following the procedures outlined in scenario 1, the landlord and tenant failed to come to an agreement to purchase the property. The landlord subsequently receives an offer to purchase the property at an amount that is at least 10% less. So they offer it for $500,000. An offer comes in $50,000 less. The seller wants to take it. At least 10% less than the lowest price previously offered to the tenant during the prior negotiations. So what that means is if during the negotiation, the seller dropped down to $400,000, that starts the 10% mark. The landlord will provide a notice to the tenant in the Office of Landlord and Tenant Affairs of the right of first refusal. And then the tenant has 30 days to deliver an offer at the same sales price as the third party offer. So
Oh my goodness.
I know. If the tenant delivers an offer at the same sales price, the landlord shall accept the offer. The landlord notifies the Office of Landlord and Tenant Affairs whether the tenant exercised the rights offered under this process. So the the things you gotta remember is the landlord tenant affairs is like your big brother over there. They're watching everything that they're doing. It is definitely not landlord friendly. Before I go into the rest of them, let's go to the document. So we can go through what we're going to be seeing. This is what Marilyn provided to us last week. And I'm going to send you out all the stuff that we're talking about today too. So let's go to Appendix A. Okay, Katie, I'm going to let you, because I am losing my voice with my laryngitis. So I'm going to turn it over to you.
Okay. Appendix A, notice of intent to sell and tenant exclusive negotiation period. The owner of your rental property intends to sell the property. Under Maryland law, you have a limited period of time to negotiate the exclusive right to negotiate with the owner to purchase the unit before the unit is placed on the market or sold to a third party. This notice of solicitation is an offer to purchase the unit. It is not intended and may not be construed as a binding contract of sale. This notice contains important information about your rights, the exclusive negotiation period, and relevant deadline. If you wish to make an offer to purchase the property, you may contract with a licensed real estate agent to create and negotiate an offer on your behalf. If you and your property owner agree on the terms of sale, either you or the seller will need to prepare a formal contract of sale to be executed by all parties. If you have questions about your exclusive negotiation period or entering into a contract of sale, you should contact an attorney. Within 30 days of the date indicated on the certificate of mailing attached to this notice, you may deliver to the owner a written offer to purchase the property.
Okay, we good so far?
Yes.
Okay.
If you either reply or decline to make an offer, or you fail to respond to this notice within 30 days, your exclusive negotiation period is terminated. The owner may sell the property to a third party. The material terms proposed by the property owner in this notice must be commercially responsible and made in good faith and adherence to generally accepted residential real estate practices. This includes the purchase price, settlement date, seller credit to buyer, if any, escrow deposit, inspection terms, radon, lead testing, down payment, and financing. It may not include restrictions on financing methods or right of inspection.
Okay, so at this point, if you're going to if the landlord's gonna make an offer, it has to have all those terms basically set forth. And the key paragraph is it may not include restrictions on financing methods or rights of inspection. So that means that they can do whatever kind of financing they want to do, and they are able to do inspections. Yes.
Maybe it said it and I wasn't listening. Talked about, how do you do delivery? Delivery have to be certified mail, regular mail, handed to you, email it to you?
There is going to be a document that they can give to them.
Okay.
If you make a timely offer that contains the same or more favorable terms than proposed by the property owner in this notice, the property owner is required by law to accept your offer. If your offer contains material terms less favorable to the property owner than those proposed in this notice, the owner must deliver a counteroffer within 5 days of receiving your offer. The owner must provide an explanation of how your offer deviates from the terms proposed in this notice.
Okay, so there's your 5 days for the seller to respond to the buyer's offer.
5 business days?
5 days. Days are days. Days are not business days.
Days. After receiving a counteroffer from the owner, you have 5 days to either accept or reject the counteroffer. If you reject the counteroffer or fail to respond to the counteroffer within 5 days, your exclusive negotiation period is terminated and the owner may sell the property to a third party. During the exclusive negotiation period, if the property owner receives an offer from a third party for an amount at least 10% lower than the lowest price proposed to you in this notice or any counteroffer, the owner must notify you and give you the opportunity to match the offer. If more than one tenant of the property delivers a timely offer to purchase the property, the owner may select the more favorable offer without liability to the other tenant.
So you could have tenants fighting for the property.
Additional information about the tenant's exclusive negotiation period, first right of refusal, and multilingual versions of these forms are available online at the Maryland Department of Housing and Community Development Office of Tenant and Landlord Affairs website at, and it's given there. If you wish to obtain free financial counseling, information on down payment assistance or financing options through the Maryland Mortgage Program or homebuyer education, please contact the Maryland Department of Housing and Community Development Office of Tenant and Landlord Affairs at 855-511-3423 or visit online.
Okay. Thank you, Katie. Your life
So going back to page 1, says if your offer contains material terms less favorable, blah, 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 5 days, the owner must provide an explanation of how the offer deviates. Does that mean like
Yes.
you're 10,000 off or what? I mean, we can't
Yes,
do
okay,
that anymore.
yes,
Of
it
what
is,
details are
it
missing,
is,
right?
it's ridiculous. So if you go down, property information,
Right?
that's all just the basic information. There is your proposed, the next page, page 3 is your proposed terms. This is $500,000, the deadline of the written offer
November
is
1st.
30 days. Proposed settlement date, all well, this would actually be completed by the property owner. This is what they want. This is all the information that they want. I hereby certify under penalty of perjury that the above information is true and correct and to my best knowledge. And so the owner fills it out, signs it. And, notice to property owner, a copy of this notice is required to be transmitted to the Office of Tenant and Landlord Affairs, either electronically or by first-class U.S. mail upon delivery to the tenant. So the day that he sends it out, she sends it to or gives it to, they don't tell you how you can deliver it necessarily, but the day that happens, they need to go on the landlord tenant affair website and register this, and it all has to be done through there. The certificate of mailing, I hereby certify that on blank day, I sent a copy of this notice via first-class mail, postage prepaid, or by delivery service, providing delivery, tracking, and confirmation number 2. So there's your, you know, what the date timestamp. Then you go to the tenant offer to purchase. Check one of the 2 boxes below indicating whether you wish to submit an offer to purchase the property. If you check the first box, leave the rest of the form blank. The first box says, we do not wish to submit an offer on the property. The rest of the form is blank if they're not going to buy it. Initial where indicated at the bottom of the page and sign where indicated on the second page, and return the form to the property owner. If you check the second box, which is offered, they want to purchase the property, fill in the rest of the form with the terms of your offer to purchase, including the proposed purchase price, settlement date, and any other material items. Initial, sign, and return to the property owner within 30 days of the date of the certificate of the mailing on the attached notice of intent to sell. So you go down and it says, important, the information you provide below, if delivered to the property owner, will, before the end of the exclusive negotiation period explained in the attached notice of intent to sell, constitute a binding offer to purchase, the terms of which, if accepted by the property owner, will be incorporated into a binding contract of sale. The section below should be filled out only if you intend to purchase the property. You should consult an attorney before delivering this offer to purchase the property to the property owner if you have any questions about your legal obligations related to such an offer and or contract. At this point, the tenant will fill out what their purchase price is, their settlement date, their inspection terms, their down payment, and their financing. Woo! Nowhere.
And their deposit.
Okay, then you go down and they have to initial, and then their deposit, their seller credit to buyer, if there's anything that's been agreed upon that they want. Seller's repair, other proposed material term. So at this point, if anything is not exactly with the way the seller wrote, it's a counteroffer. And but that's where they're not asking for a qualification letter. I can't see anywhere where they have to supply anything like that. So basically they could hold up the landlord for 30 days and not really be qualified. And then information about the tenant's exclusive negotiation period right of refusal and multilingual versions of these forms are available at the Maryland Department of Housing and Community Development. And if you have any questions, again, you go to the Maryland Department of Housing and Community Development. Yes, Paul.
Back to the very first page, the
Mhm.
next to last bullet on the bottom. What I'm gonna talk about. So I'm the property owner. I let you know I want 200,000 and other details. You come back with a counter offer saying 190,000. This next to last bullet says, if your offer contains material terms less favorable to the property owner than those proposed in this notice, that I, the owner, must deliver a counter offer back again. I've already told you I want 200,000. You said 190, so my counter offer is going to be
200,000.
200,000. So I just stated.
But it might be, I mean, there might be a
Right.
case where somebody would take 195, let's
Right.
say, or something like that. So there is,
But I'm required to do a counter offer. I can't just reject it.
you counter a full price.
Well, but this, yeah, exactly.
And
Okay.
yeah. It's very time consuming for us. You have to know that a landlord, if you have clients who are, thinking of selling, or even if they have tenants in the property right now, it would behoove you to talk to them and send this information out to them now so that they have as much lead time as possible if they're going to think about selling. You don't want to get them into a position where they have to sell the property like in 30 days and this is going on and the tenant has, waits till day 29 to say, nah, I don't want to buy it. So I think the timeframes, I get the point, and I like that the tenants have the opportunity to buy it. And, there's a lot of noise right now with real estate agents because of multiple offers and stuff like that, that you don't have an opportunity to put it on the market for multiple offers and all that. And that is absolutely true. The thing is like the real estate market isn't going to be like that forever either. And so I think what they're trying to do is to make housing more affordable for first-time buyers, such as tenants. And I think tenants, housing is very difficult for tenants right now. And I think that that's what they're trying to create, is an environment where tenants have an opportunity for home ownership.
And give them ample time.
And give them
So
ample time.
You can't just, speaking from the tenant's point of view, you can't just drop it on me, hey, here, you're selling a house and you're putting it on the market tomorrow.
Right.
Give me some time you can't surprise me with it. Let me see what I can do.
Right. Right. So as long as they have enough advance, our landlords have enough advance warning, it shouldn't be as big of a deal as we're making it right now. And, in practice, it won't be, as long as we are doing our job as realtors and getting the word out to our landlords that this is a thing. Let's see, sorry. Okay. So we're going to jump to Appendix B. So when the counteroffer happens, the owner of your rental property has not accepted your offer to purchase because it varied from the terms proposed in the notice of the intent to sell. Under Maryland law, the owner must present you with a counteroffer and an explanation of how your offer varied from the terms proposed in the original notice of intent to sell you received. This counteroffer is only valid for 5 days after you receive it, unless the property owner has agreed in writing for a longer period. If you do not respond to this counteroffer within 5 days of the receipt, it will be deemed to have been rejected and the owner may sell the property to a third party. Please read the information below carefully and return page 3 to the owner within 5 days after indicating whether you accept or reject the counteroffer. So at this is how the counteroffer is going to go back. And I think the reason that they have this and that they have that paragraph that says, how does it differ from these, how did their offer differ, is because they want to be clear that you are not turning down a counteroffer that is virtually the same. So the property address, all that stuff goes in there. The proposed inspection terms, whatever, tenant may not be required to waive inspections. Financing, seller may not place restrictions on buyer's method of financing. Other proposed material terms, and then the tenant's offer to purchase deviated from the terms proposed in the original notice of intent to sell as follows. So you can't write in here, the seller won't accept an inspection or something like that. So the reason that they just wanted to have something pointed out that is actually a legitimate reason that you don't have to accept their offer. So here you would put buyer's offer $10,000 less than original price, or whatever the terms may be. They write it there, they sign it. And then you go to tenant's response to the counteroffer. And they're going to check one of the boxes, important, and return to the owner within 5 days. This is all 5 days, 5 days, 5 days. If you reject or fail to respond within 5 days to the owner's counteroffer, your exclusive negotiation period and right of first refusal are terminated, and the owner may sell the property to a third party. If you accept the terms of the counteroffer, you are making a binding agreement to purchase the property, and neither you or the owner will need to have a binding contract of sale prepared for execution by all parties. The second box below should be checked only if you intend to purchase the property on the terms of the owner's counteroffer. You should consult an attorney before delivering the response to the property owner. If you have any questions about your legal obligations related to such an offer and or contract, contact an attorney. So you either accept or you reject at this point as for the counteroffer. And again, the disclaimer at the bottom that they can go to the Maryland Department of Housing and Community Developments or Landlord Tenant Affairs. They also, you know, this is all the disclosures. So, and that's it. So you, basically the timeline is from the date that you offer them the option to purchase. Like this is what we want. They have 30 days to respond. Day 29, they say they want to make an offer. They want to do it, but they want to make a counter offer. The landlord then has 5 days to respond back, whether they accept it or make another counter offer. And then the tenant has 5 more days to accept the seller's counter offer, if they counter offer. That's it. At the end of that, then the landlord is free to sell it on the open market. All this has to be done through the Landlord Tenant Affairs website. Tenant's first right of refusal. And I will send you again all the links to all of this. There was some other good information. And Paul, you don't have these, but there's a bunch of information that you can give to renters. You can give it to the sellers so they understand what they're in for. The most important thing the landlords need to know is timing, and that this thing has to all go on record. It has to all be, you know, out there for them to look at, so that everybody knows that tenants are being helped in this process, and they're being given the opportunity to purchase the property if they want to.
And all of these forms need to go to the Department of.
They go in here, and I don't have an account, so I can't actually get in here. I was gonna sign up my house, but I didn't.
You can do it. Appendix C.
Oh, I didn't do Appendix C, sorry.
Mhm.
Okay, I skipped over Appendix C, sorry.
Notice of
Marilyn,
intent to sell
Katie, can read that.
and tenant's right of first refusal. The owner of your rental property has received an offer to purchase the property and intends to sell it. Under Maryland law, you have, for a limited period of time, the right to make an offer to purchase the unit at the same price as the existing offer before the unit is sold to a third party. This notice is a solicitation of an offer to purchase the unit and is not intended as, and may not be construed as, a binding contract of sale. Please read the information below carefully, as it contains important information about your right of first refusal and relevant deadlines. If you wish to make an offer to purchase the property, you may contract with a licensed real estate agent to create and negotiate an offer on your behalf. If you and the property owner agree on terms of sale, either you or the seller may need to prepare a formal contract of sale to be executed by all parties. If you have any questions about your right to purchase or entering into a contract of sale, you should contact an attorney. Within 30 days of delivery of this notice, you may deliver to the owner a written offer to purchase the property. If you make a timely offer to purchase the property at the same price as the existing offer received by the property owner and described on the second page of this notice, the property owner is required by law to accept your offer. The owner is not required to accept an offer you make that has a purchase price lower than that in the existing offer. Your right of first refusal is terminated, and the owner may sell the property to a third party if you affirmatively decline to make an offer, fail to respond to this notice within 30 days, or make an offer with a purchase price lower than that in the existing offer and the owner rejects your offer. If the property owner accepts your offer to purchase the property and enters into a contract of sale with you, but the contract is terminated before settlement, your first right of refusal is terminated and the owner may sell the property to a third party. If more than one tenant of the property delivers a timely offer to purchase the property, the owner may select the more favorable offer without liability to the other tenant.
Okay. Questions?
Seems like this ought to be A and get rid of the first one.
Well, it depends on how you do it.
Right.
You know,
So what was the question?
Yeah, I asked you how many questions, and Paul said it seems like C should be A. But if you do it the way that it's intended, by putting it, going to the tenant first, delivering your notice, appendix A, with the offer 30 days prior to offering it for sale, then it's done. If you put the house on the market at the simultaneously offering it to the buyer or to the tenant, this issue is going to come up. So you would use C, where at that point you have an offer that maybe let's say a scenario comes up where somebody approaches the landlord and says, it's not even on the market. And they say, I would really like to buy your property. I want to live in this neighborhood. And, they have tenants in it. So this is the process you're going to need to do. Then you're going to need to do appendix C, where you say, this is the terms that I've been offered. The tenants now have the first right of refusal. They still have their 30 days. So this offer has to sit for 30 days unless the tenant says, no, I don't want it. No, I'm not going to be able to buy it or what have you. But in the event, like I said, if it happens in that scenario, do you understand the scenario I'm talking about?
Yeah.
Okay, thanks, Paul. This is what you're gonna fill out this form then. And basically it's detailing the terms of, I'm sorry, I gotta get back to where I was. The terms of the existing offer that's going to be sent to the tenant. And they're going to certify the date of the mailing to start their 30 days. And then the tenant goes through the same process. They have no interest in buying the property, or they do have interest in buying the property within 30 days. And then they already know what the other offer is. This is what the tenant's offering. Let's say the tenant's offering $10,000 more. They have to give it to the tenant. Or if they offer the same, they have to give it to the tenant. And all this has to be done openly through landlord-tenant affairs.
Julie, how do landlords know that this law went into
They don't.
effect?
They may. It depends. Like, I think a lot of the property management companies, if they work with a property management company, they probably are getting information on it now. But that's why I'm getting this to you. That's why I sent it out to you. The minute I saw it, I knew it was coming on, and we just didn't have anything to work with. Like I said, we didn't get these addendums until Friday. I think it was Friday. Anyway, whatever, last week. And that's why I wanted to set up something as soon as possible. And that's why I'm recording this, because I don't think people understand what a big deal this is.
Right.
And it's going to, I don't know what the ramifications are. I really don't know what the ramifications are if a landlord is caught not following procedure. I mean, there's probably penalties, which I don't know what they are, but
But I'm thinking, like, if I'm a tenant and I receive something like this from the owner of the property, and I'm working out all these details back and forth with the owner. We've agreed to a purchase price. And now I'm like, oh my gosh, okay, now we have to have an official contract of sale. And I need to get representation. I have not negotiated any part of that, realizing that I might have to pay for buyer agent representation on top of what I've already agreed to.
True. True. So, yeah. So that's why I think, as realtors, we need to get the word out there that this is happening. And I know that this was fought pretty hard by, the realtors, lobbyists and all that to make this not the way it was. Apparently it was a lot worse than this for landlords, and this was the compromise. But
And is this strictly a Maryland law, or is Maryland just late to adopting this law? It's
this is a
also other.
Maryland law. And I don't know, I think it's one of the few, I think I read somewhere that it is one of the few states that have something like this.
California probably does.
Yeah,
California
something.
probably does.
Let's see, it's right here. It says, changing the housing landscape for renters in Maryland. The act, which takes effect October 1st, creates the first statewide tenant opportunity. I thought it said something about other states, but I don't believe that a lot of states have this. So I think that it's going to come as a shock, I think, to a lot of the landlords that they have to jump through these hoops, especially if they think they're sitting on this property that they want to put on the market and get multiple offers on. So we got to remember, a lot of these properties are going to be first-time home buyer properties at lower prices that are like still flying off the shelf.
Right.
So, I guess it's an opportunity for us to get out there and tell landlords, be the one that lets them know about it, show them that, that you're a professional and you understand the law. You're not making the law, you're just passing it along because you want them to be on the right side of the law when this happens. And like I said, I don't know anybody who has used it yet, but I do know, I'm trying to think who, someone in our office actually sold a tenant occupied property, but it actually had settled before the October 1st. And they wanted to make sure that everything was done properly. And it turns out there was a reason why it didn't have to go through it, but they are all over this when something settles. So I imagine that the title companies are going to review this and make sure that everything was done properly, because I think that it could get really ugly if people don't follow the procedure. Lawsuits, if a tenant says they were not afforded their right by law to purchase this property, it could get really ugly. So I think we have to be the ones leading the charge of making sure that our landlords know about this.
Right, so if somebody contacts Mark and says, okay, I have a rental property that I'm ready to sell. I have tenants in it right now. It's Mark's responsibility to advise them about all of this and the process, if they don't know about it already.
I think that we do have a responsibility as realtors to know the process. So it's the landlord's responsibility to do this, and they should know also, because there's a level of knowledge that landlords are supposed to have. They're supposed to be aware of all the laws that are happening in landlord-tenant affairs. But as realtors, we also need to make sure, because we don't have the right to sell it. And we know that.
Well, I know that landlords are supposed to register their rental properties. So I would assume if they can send it out to everyone that has a registered rental property that this is a new law.
Yeah, I
If
mean,
it's
most,
not registered,
most counties are now making landlords register their property. But yeah, there are people who have not registered and they are not in compliance with the
Mhm.
law.
right,
But
Julie, these documents like this one you're showing here, like we're able to forward that to somebody.
sure, yep, they are for the public. So
Okay.
I'll get you the links to all this stuff so that you can, have a nice copy. And I'll send you these, all of these documents that I have here. I have several of them. I have Renters' Rights and Stabilization Act for law enforcement and legal partners. And then this is Renters' Rights and Stabilization Act, frequently asked questions. And then I have Renters' Rights and Stabilization Act for renters and homeowners. This might be, a good one to to send to your
yeah,
landlord, especially.
Yeah,
Yeah. And then I will also send out the summary of everything that we went over. The other thing I wanted to mention too is security deposits. Security deposits can only be, you can only hold 1 month security deposit. Doesn't matter whether they have pets, bad credit, 1 month is all you can take.
There's a limit to it, has to has to be the same as a 1 month's rent.
right.
One
You
month's
can't
rent.
add the pet
Some-
deposit
yep.
onto that or
Some
anything.
people-
You can do a $500 security deposit and a $500 whatever pet rent, but it can only be if your rent is $1,000, that's all you can do. Oh, and the question came up from Paul, is it residential and commercial? It's just residential. Landlords may not charge a security deposit exceeding 1 month's rent. However, a landlord may charge up to 2 months' rent if the tenant receives qualifying utility assistance and makes their utility payments directly to the landlord. That is the only exception. Then it goes through all the eviction process, which we're not going to go through today, but it might be good to hand that information out to your landlord clients. What other questions we have? Nothing? I did a good job?
Good job.
Very
Okay.
good job.
Yeah, it's a big deal.
it's huge. This is big.
Very big. We're going through some big stuff this year, we're
Yeah.
changing a lot of things. And I think that's why this was coming out late, is because it was on the heels of changing all of our contracts and our,
Mhm.
we're still working on a lot of stuff. Working on
So
some of
Julie,
the-
I guess a question I have, is there, in this particular case of a sale, our regular contract of sale, like the Maryland contract of sale, would those terms that they had initially agreed upon need to be attached to that initial contract of sale?
No.
To that final contract of sale?
It's
I guess.
already, no, you would just do a new contract of sale and everybody would sign it. I don't think it's necessary to have the other thing. The other documents are part of the file, let's say, but it's not part of the contract.
Okay, so two separate things.
Yeah.
Okay.
I have a question. If you have a tenant that advises you at the end of their lease that they are leaving and they're moving out, do you still have to offer them
Good
this
question, Katie.
if you intend to sell it?
I woke up this morning thinking that same question. I believe as long as the tenants have vacated and ended their lease, it's done. I've got no other information saying that you owe them any kind of like retroactive anything. So until I hear otherwise, that is, I will look into that, because I did think about that this morning. If you get notice of somebody leaving, if you just wait until they move out and then market the property,
Right, that's what I was thinking.
and they have not addressed that scenario.
Because in that case,
No.
they've left, their lease is over, they're gone.
They're no longer a tenant.
They're not a
They're no longer a
tenant.
tenant.
Yeah.
That would be what I
The
say
catch
too.
is if they give you 30 days notice, and this is 30 days, and now you're on date, so just do it,
Ye-
CYA.
Yeah, you might as well offer it to the tenant, but the only thing is that if you decide to sell it, let's say you thought they were gonna live there for 2 more years, because and they decide not to renew their lease, and you're kind of up against the wall and you gotta, sell at that point. then you do it, or, because there's no reason not to offer it to them 30 days
Mhm.
prior, unless you really think you're gonna get like multiple offers by putting it on the open market. So, this is like everything else. This is the original documents that they've come up with. It's all, it's a living thing that as things happen, as they find, shoot holes in it, people find workarounds, they're gonna change this. It's like our new contracts. They're already working on new contracts. So, this is what we have to work with. I would suggest, if they have any questions, they can you give them the information and they can contact an attorney. And then tell them about, what does happen if we write a contract, that maybe there has to be something written in there that, for offer of compensation to the agent from the tenant because they want some representation. It's all going to be this fluid thing that we don't really know how it's going to play out. So, anyway, the most important part is that you get the word out on the street, and you get your clients protected if they're landlords, for sure. And the tenants, it could be an opportunity to have a tenant, sell a house to a tenant.
Right.
And you might be the one who the landlord hires to write the offer for the, both sides. You might just be you may not represent either party. You may just write an offer for them. It's, like I said, it's going to be it's going to be interesting to see how it plays out. I think a lot of property management companies are going to probably change their contracts where they are written in as the one who writes the offer for the landlord or something to that scenario, and they may even address the question of having representation for a tenant down the road. But until that time, it's kind of the Wild West for us, and we just have to play by what the rules are now. And if you get stuck with something, we can talk through it. We can get a second opinion from an attorney if we get into a situation that we have questions with. And I think that's all we can do right now.
Okay.
But it's definitely an opportunity to reach out to your clients who have tenants living in their houses. And I would not wait on that either. So, well, I hope you found this helpful, and
Thank you, Jolene.
and I hope that, we work through this like everything else, and it's seamless, and it'll become second nature to us in no time, right?
Right. Absolutely.
Okay, call me anytime if you guys have questions, okay?
Thank you.
All right, you guys have a great day.
You as well.
Bye.
Like someone like Dan has